The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have 3 cases that will be submitted. Those cases are in re the interest of QG and WG. Second case is Martin Shane Moon versus the State of Iowa. And the final case is Francisco Villa Magana versus State of Iowa. Those last 2 cases are now submitted to the court without an oral argument, and we will hear the arguments in re the interest of QG and WG. Mr. Gangestad.
Honorable Justices of the Supreme Court, Counsel, may it please the Court. Your Honors, I'm Grant Gangestad. I represent the applicant respondent in this case, who is the biological father of the 2 children at issue in this action. I believe that a very brief procedural history will be helpful to the Court's understanding of the issues. In 2015, my client was sentenced on charges of domestic assault, drug possession, and child endangerment as part of a plea deal. He was incarcerated as a result. And during his incarceration, the appellant and appellee were parties to a dissolution of marriage, and they stipulated to a divorce decree. In that stipulation, the stipulation stated that the appellee would have legal custody subject to the appellant's right to supervised visitation. The parties agreed that phone, mail, email, and visiting between the appellant and the children would be considered by the appellee upon him being active in the required treatment by the DOC, or Department of Corrections. The parties also agreed that if the appellee refused visitation when he was active in this treatment, or if he was released from prison, the court specifically retained jurisdiction to consider modification of the custody provisions of the decree in the continuing best interests of the children. That stipulation was filed on August 11th of 2016. 4 days later, the appellee filed this application for termination. 2 months later, in October of 2016, the appellant was offered for the first time to complete that DOC offender programming, which he did complete prior to the termination hearing in this matter. While involved in that treatment, he requested contact with the children, which was denied by the appellee. And the following month, the court held the hearing on the termination action and terminated the appellant's rights. He was never given an opportunity to exercise the visitation that was specifically agreed to by the parties and confirmed by the district court. When a parent agrees to a custody arrangement and completes everything that they need to do to fulfill that arrangement and to become a better parent, justice is not served by allowing the other parent to move the goalposts on them when they get close to the end zone by seeking a private termination. That's not justice. The appellant raises 2 issues in this application for further review. First, the juvenile court did not have jurisdiction in a private termination action under Iowa Code Chapter 600A to terminate the appellant's parental rights.
Well, okay, let's start there. Of jurisdiction and termination of parental rights vested in the juvenile court? I mean, the legislature uses the term exclusive, right?
Not the way that I read the statute. Under 600A.3, the statute states, and I believe that the appellee conflates the terms exclusive remedy and exclusive jurisdiction. 600A.3 provides that Chapter 600A is the exclusive means for which to order a termination, thus providing the process for a private termination, but does not provide for exclusive jurisdiction like Chapter 232. Chapter 232 has specific provisions that state we are the exclusive court and no other court can have jurisdiction while we have jurisdiction unless it's granted to them. That is not the case in 600A.
Does the dissolution court have authority to sever parental rights?
Under 600A, I believe they would. when interpreting laws, the court is guided by a Latin rule that I'm not even going to attempt to pronounce, but this rule recognizes that the legislative intent is expressed by omission as well as inclusion, and the express mention of one thing implies the exclusion of others not so mentioned. Had the legislature intended for those exclusivity provisions in 232 to apply to 600A, they certainly would have said so. The appellant's not saying that the juvenile court can never have jurisdiction under Chapter 600A, but where there is a prior order to the contrary which retains that dissolution district court jurisdiction. And because there is no exclusivity of jurisdiction under 600A, the district court did properly retain jurisdiction in this matter because they had jurisdiction first.
All divorce decrees where you deal with children and visitation and those type issues, doesn't the district court sort of keep jurisdiction over that case in order to modify, in order to solve disputes, in order to solve contempt?
Correct, Your Honor.
And if that's the case, then a juvenile court could never go in and terminate if there's an abandonment or some other ground under 600A? Is that what you're saying?
No, Your Honor. I'm saying that where there is a prior court order, I guess there are two different situations that could be possible under 600A. Where there has been a child and there has never been a court order, in which case a 600A application could be filed and the juvenile court could hear that. If there is a prior court order of the district court, then the district court would retain jurisdiction to hear any changes to that order.
It doesn't really retain jurisdiction. It's the place you go to modify custody, but they're not overseeing the dissolution as it goes on and unless some party brings it to them. I mean, once that decree's entered, I think it's done. I mean, and if someone wants to revisit a decree or say someone's in contempt, they go to juvenile court, but it's not retaining jurisdiction sort of like an injunction where they desegregate schools, where the court maintains jurisdiction to make sure that the desegregation plan is followed.
Well, this
I mean, it's a different animal.
This court has said that a dissolution court retains subject matter jurisdiction to modify its decree. There was a decree here allowing what the appellee did.
Retaining subject matter jurisdiction is different than retaining jurisdiction over a specific case.
And the subject matter jurisdiction, I believe, that was retained in this case was particularly the custody portion of that case. There has been cases as far back as 1941 in Drosty versus Drosty, which is 1 Northwest 2nd, 107. It's a 1941 case. It said the court has approved retention of subject matter jurisdiction over custody provisions of a decree. Here, the district court specifically did so to anticipating a situation where the appellee may interfere with the appellant's right to visitation.
My problem is if we adopt your view, and maybe I'm wrong and you need to tell me if I'm wrong, is that every time there's a dissolution and there's a decree dealing with some kind of custody matter, you could never have a 600A termination. Is that what you're saying? Because the dissolution court always maintains or retains jurisdiction.
I think in that situation where the district court retains jurisdiction as far as the custody goes, then the district court, the dissolution court, would have to determine whether or not a 600A application was appropriate.
But, you know, we see it all the time, though, where there's a dissolution action, the custody's awarded, mom or dad disappears, abandons the kid, and then we see a 600A. And we've never, you know, if it is subject matter jurisdiction, you know, we can raise it. I've never seen a court raise it. I've never seen a party raise it. I've never seen a case that says you can't do it if there's a dissolution decree and the kid's still a minor. I don't know where, I just don't know where your authority is.
I don't think there's authority one way or the other. I've looked for authority from this court and other courts in Iowa and have not ever found a situation where specifically custody has been established, a 600A termination had been filed, and then the court was able to essentially relitigate, or excuse me, the parties were essentially able to relitigate the circumstances that had already been determined by that district court.
There is a Court of Appeals case, I think it's ARN, another unpublished Court of Appeals case from 2012, different panel that goes 180 degrees the opposite of the way this one went. It goes in your direction. But it's not jurisdictional. It's more of a judicial estoppel rationale, which strikes me as your better argument, that you sign a decree, you enter a decree, and then 4 days later you go to a different forum to try to, in essence, get that decree overturned. That's troubling to me. I have more difficulty buying your general proposition that you can't file a private termination action when there's a custody provision that talks about the possibility of ongoing jurisdiction.
Certainly, if the court determines that the district associate court sitting in juvenile jurisdiction did properly hear this matter, it is our secondary position that the court's consideration of evidence that was already determined by the district court would be improper and would be reversible error, because we're essentially allowing the appellee to relitigate determinations that were already made. That is basically, in some respect, allowing judge shopping.
Well, we really aren't, because it's not like an issue preclusion matter where they actually litigated this before. I mean, it was a stipulated agreement. The guy's going off to prison or is in prison, I'm not sure which, and they simply enter into an agreement where she's going to have sole custody and can control visitation if and when circumstances allow, or when he gets out of prison. So we really don't have a real formal adjudication, I would call it, on that, do we?
Well, I think the result would be the same in either case. If there would be a actual litigated case, a person could get a decision that they don't agree with and then file a 600A action a month later and try to get a different result from a different judge. It's essentially what we have here. There is a stipulation, the parties agree, there's a final decision in the matter, and then they backdoor that decision, and what they stipulated to in order to get a different result. I don't know if it was buyer's remorse, I don't know if it was something else, but in either case, we have the party seeking a second opinion.
Did the stipulation include any of the grounds alleged to terminate?
Could you rephrase that for me?
Did the stipulation of the parties stipulate any of the matters that were included as grounds for termination?
No. There were no specific stipulations that there were grounds to terminate. It was contemplated in the decree that he was incarcerated, because the decree talked about the things he'd need to do through the DOC and participate in offender treatment. But it did not specifically state any of the grounds for termination or that any of those grounds had been met. Our position is, if the court finds that the juvenile court did have jurisdiction, that this is somewhat akin to a modification of custody. If you are asking for a termination, there needs to be new and separate circumstances for that termination to be entered. Modifications are guided by well-established principles.
Well, what if we had a situation where there was a stipulated decree, dad was required to pay $50 a month, didn't pay it for 4 years, didn't pay it from day one, and then you have a financial abandonment, and you have a grounds to terminate. I mean, you're telling us you can't terminate under those circumstances?
Well, that would be new circumstances from the entry of the decree. That would be a ground that was available or made available to the court after the entry of the decree. So if he doesn't pay for 4 years after the decree, those are new circumstances that the court can consider in finding abandonment. Here, my client was incarcerated the entire time and was not allowed to have contact with his children. So there was nothing that he did in the interim that changes that best interest determination that the original district court had.
Well, then isn't it a question of whether or not it's in the best interest to terminate the child? I mean, the parent relationship while the father's in jail so freshly after the decree was entered? I mean, isn't that a sort of a different argument than a jurisdiction argument and some of the ones you're trying to make?
Well, I think the jurisdictional argument and the argument that the decree was so fresh that there was no new circumstances to justify a termination, those are the two issues that we're arguing here. First, the jurisdictional issue, obviously asking that the district court retained that jurisdiction. Second argument and separate argument is that if the juvenile court did have jurisdiction, the court can't consider any of the circumstances that went into the court's best interest determination. In any stipulation, even in approving a stipulation, even if it's not litigated, the court has to, and its role is to determine what the best interests of the children are in approving a stipulation. So that being said, there had to be an appeal, essentially, if they wanted to say that that stipulation was not in the best interest of the children. That was not done, and in this case, essentially the appellee used a backdoor procedure to get around what they decided they didn't want to any longer hold themselves to. My client was getting close to being able to assert his rights. He had done everything he needed to do. He was a model prisoner. We want to promote, obviously, finality of decisions, and this does not, the procedure that was used does not promote that finality.
I guess I have a question, and I don't know if you have the answer to it or not, but typically when I have seen these kinds of cases, it seems to me that it's always filed in the district court, and in fact it says it's to be filed with the district court. Why in this case is it docketed and tried as a juvenile matter if this is kind of to me it's a separate remedy that's provided, similar to the dissolution statute and custody statute? Why is this brought as a juvenile court action in the first place?
And I see I'm out of time. I may answer.
You may.
To be honest with you, I don't know how it was docketed that way. It didn't appear to me that there was a special assignment of any nature. I honestly couldn't tell you why specifically it was tried at the juvenile court. And I will say that prior to the hearing taking place, there was no motion to remove it to district court. However, our belief is that this is subject matter jurisdiction which can be raised at any time. Thank you, Your Honors.
Mr. Gangestad, thank you as well. Ms. Eisentrager?
May it please the court. My name is Dani Eisentrager, and I represent the appellee mother in this case.
I guess I'll ask you the same question. If you know, to me this typically, it seems to me, is filed, in the district court, so it's docketed as a regular civil action to terminate. But this one is, of course, docketed and tried and heard, everything under the juvenile court number, a juvenile assignment, juvenile docket. Can you explain why that was, or what's the authority for filing it under the juvenile court docket?
Sure, I can. When an action is filed under 600A, if you look at the statute, it talks throughout the statute about the juvenile court determining grounds and finding that. If you refer to Iowa Code 232.6, it gives the juvenile court the ability to exercise jurisdiction over termination of parental rights cases under 600A. And that's what happened in this case. So this started as a filing under 600A for a petition for termination of parental rights. There's no dispute by any party that the grounds for termination existed.
Here's what bothers me. You have a stipulated, you and your client enter into a stipulation that Mr. Gangestad read to the court regarding visitation and the possibility even of a modification of the arrangements down the road and things like that. Then 4 days later, you file a private termination. Now, I have to guess the father was not expecting you were going to turn around and file a private termination 4 days later, right?
And just for clarification, that 4-day time frame isn't quite accurate. We were in court in May, early May. It was done via phone due to the father's incarceration. Everything was done on the record at that time, even though the parties had come to this potential agreement. But Mr. or the father didn't sign off on it for several months, which is why it was not filed and approved with the court until it was returned by the father.
But it still was, after it was actually filed 4 days later, and regardless of whether the time period's 4 days or 4 months, nothing had really changed, right?
Right, and I can address somewhat your ARN question, because if I read that case, it appears to me the problem there was the grounds that they were seeking were abandonment. Here the grounds are completely separate. Even though the juvenile court did find grounds for abandonment of the father, that wasn't the grounds that everybody's agreed to have occurred. The grounds are simply that the father has committed a crime against the child.
It's still essentially, you're right, it was a little, the facts are a little different. I think the father there had committed arson against and the mother was a potential victim, I guess, of the arson. And, but the rationale of the court is exactly the same. The court says, the doctrine of judicial estoppel prevented her from pursuing the petition to terminate at that time. Yeah, okay, you can do it later on if the facts change, but this is really an attempt to sidestep the visitation stipulation incorporated into the decree. Why doesn't that rationale apply here?
I think, again, I would tell you, because I think the grounds are different, and I would disagree that the juvenile court did not of this matter, and the best interest determination by the juvenile court under 600A is not the same best interest standard under 598 that would have been determined by the court in approving that stipulation of the parties. And so that is part of the problem as well.
I mean, I'm not saying you'd be barred if, I'm not saying the state would be barred if they wanted to step in and terminate parental rights, but it strikes me as a parental determination where the parties are the mother and the father. That hasn't, in essence, a stipulation been reached on that, on those issues in the divorce decree?
Well, and the stipulation gives the mother sole legal and physical custody with basically the right to determine what contact, if any, and if not, it had to come back before the district court, who had made that decision to approve that stipulation in the children's best interest.
But doesn't the decree nevertheless constitute a finding by the court that a custodial relationship would be in the best interest of the child?
Right, because under 598, that is the best interest standard, which is different than under 600A. But the juvenile court in this matter was well aware of that. They had access to that and knew about that finding, which is something they absolutely considered and should have considered.
Why is it different under 600A? What's the difference between the best interest of the child under 600A?
So under 600A, best interest is, it requires the court to determine if each parent has affirmatively assumed the duties encompassed by the role of being a parent. The court, in determining this, considers, but is not limited to, fulfillment of financial obligations, demonstration of continued interest in the child, demonstration of a genuine effort to maintain communication with the child, and the establishment of and maintenance of a place of importance in the child's life. Now, different compared to 598, again, includes but is not limited to the opportunity for maximum continuous physical and emotional contact possible with both parents, unless direct physical or significant emotional harm to the child may result from this contact. Refusal by one parent to provide this opportunity without just cause shall be considered harmful to the best interest of the child. And then, under 600A and under 232, this court has expanded the best interest determination, not for 598, but for those types of actions, to include that in seeking out the best interests, we look at the child's long range as well as immediate interest. This requires considering what the future will hold for the child if returned to the parent. When making this decision, we look at the parent's past performance because it may indicate the quality of care the parent is capable of providing in the future in the interest of CK. So
Don't
to
you
say
think the
that
598 best interest, I mean, you seem to say the same thing different ways. It seems to me that the 598 best interest considers some of those 600 best interests, And basically, it's what's best for the child and what type of relationship the parent can have with the child based on the parent's circumstances. And clearly, with the father in jail, his limited contact with the child was created because he was in jail. And when they set up the visitation rights, the court said it's in the best interest to maintain that relationship. And I don't know how, I guess I have the same problem Justice Mansfield does, how it changes under 600A 4 days later.
Right, and again, the other thing that under 600A that's considered is the parents' rights as well. So when we're looking at best interest under 598, we are only talking about the child. Under 600A, we are looking at everyone involved. So that is somewhat of a difference.
Well, it is, but it doesn't seem to me to be, I mean, overall, I think under any of the statutes, we're always looking under the best interest of the child, or we ought to be looking under the best interest of the child. And again, when we make determinations about custody and visitation, I'm really not that concerned about mom and dad, you know, and what their feelings might be about all this. And if that's a factor, and I guess you're telling me it's a factor under 600A that I have to now consider, oh, well, how's mom gonna feel about this, or how's dad gonna feel about that? I don't think that should be an overarching consideration of mine when I'm considering the best interest of the child. So, you know, that's just my
Sure,
feeling.
and I, you know, that's a legislature thing, because they've put two different definitions in each of the different statutes.
It seems underhanded to me that the mother would enter into a stipulation agreeing to cooperate with facilitating child visits and then turn around and seek to terminate the rights. Why shouldn't we stop her from doing that?
And again, it was at her discretion whether she thought, you know, it was appropriate, and then if it wasn't, then it was going to be back before the court to determine if it was appropriate. The 600A provisions are exclusive, so if somebody needs to get a divorce, I am not sure how to reconcile that,
It
because
doesn't quite say exclusive. I mean, your opposition counsel has a point. I mean, it was a phrase, in fact, that I used, but the statute itself says termination of parental rights shall be accomplished only according to the provisions of this chapter.
Yes, but then under 232.6, when the juvenile court exercises jurisdiction, because it specifically gives them the right to do that under 600A, they then have exclusive jurisdiction. This was absolutely the juvenile court. Court order that comes out of the district court says juvenile division. It was a district associate court judge.
But we're still a unified court system. We may have different judges and we may have different courts, but they all operate in unison.
True, except for the juvenile court is given that hierarchy of jurisdiction on things for the protection of children. I mean, there's no doubt about that. That's why there's that exclusive provision under 232, which again ties to 600A, because the juvenile court was exercising jurisdiction in this case.
Were there any facts that were different before between the district court in the dissolution and the juvenile court in the termination?
Yes, and the Court of Appeals also determined that they would have found that even if the juvenile court did not have the jurisdiction to make a determination here, that if there had to be a change or to look at a change in circumstance, that was found. Some of the things that were laid out by not only the juvenile court but the Court of Appeals was that the father had not taken any responsibility for his actions but continued at the time of the termination hearing to blame the mother.
Those were all, well, you're right. I mean, that's true. That part about blaming the mother, that was the testimony. And I agree, the father doesn't have the greatest equities in the world, to put it mildly. But most of what the Court of Appeals talks about are things that happened prior to August of 2016, when the stipulation was filed, and then 4 days later the termination petition was entered. There really wasn't much that changed between August and whenever the thing was heard, just a few months after that.
November is when the termination trial was.
Yeah, so
in
it's
addition,
3 months later.
Sure. The mother had remarried, and the husband of the mother was actively involved in caring for the children. There had been harassment and unhealthy behavior between the mother and the father's family. The juvenile court found that to happen. The guardian ad litem recommended termination of parental rights as being in the children's best interest, and the father hadn't made any contact. Understandable that he was prevented up until a point in time, but had done nothing. I think the juvenile court indicated he had the right under the court order to contact the school to obtain records. He had done none of that at the juvenile court.
Well, had he been doing that before the dissolution ended?
I don't know the answer to that. I don't believe so.
What? The record wouldn't support that, I assume.
I don't believe so.
Why did you put the paragraph in? I mean, this stipulation, why not just obtain a divorce decree without this language? And then you'd have a much cleaner argument that, all right, the divorce occurred, and now we're going to seek a private termination. Why have this provision about phone, mail, O-mail, and visiting being considered when it really wasn't going to be considered? You were really planning to file a private termination petition.
Well, and again, I would maintain that the issues of those types of things were always subject to a modification by the district court of that original order and stipulation. But under 600A, once the grounds and best interests were determined by the juvenile court, that order became null and void.
At the time the stipulation was negotiated and signed, did you and your client intend to file a termination action?
No, and if you recall, we were at trial because there wasn't a stipulation until such time as it was read on the record by the father's attorney, who was a different attorney than Mr. Gangestad. Mr. Gangestad did not represent him at the time of the dissolution. And so I would say, no, that was not the intention of anybody at that time. And again, that was several months prior to when it was actually approved.
As a matter of judicial estoppel is a discretionary doctrine. We can apply it when we think the equities require it. But in this context, when the paramount concern is for the best interest of the children, should we defer to the juvenile court's determination and not stop the mother from filing such an action?
I think that is what is required of the juvenile court to make that determination. I think the juvenile court in this case did a good job of going into all of the details of looking at everything to determine best interest when deciding to terminate the father's rights. And I am just about out of time. Thank you.
Thank you as well, counsel. Rebuttal?
Your Honor, I just want to respond briefly to the argument made by the appellee that the contact was at the appellee's discretion. That is partially true. However, the stipulation goes on to state that if she was refusing or withholding visitation unnecessarily, then he could request a modification to have the stipulation modified. He had been active in everything that he needed to do. He was active in the treatment. There was no DOC policy at that point that was preventing him from going forward with communication. So I think that it was solely in her discretion is somewhat of a misnomer.
Counsel, if this stipulated dissolution decree did not exist and we were looking exclusively at the grounds to terminate, would you have anything to appeal?
If there was never a custody order in place, the appellee certainly had the ability to file a 600-day termination action prior to the court's order. In that case, we could certainly still, I believe that there would be grounds for termination, but certainly the best interest determination is certainly something that could be appealable in this case. I do believe that there does need to be some deference given to the district court in this case that approved a stipulation that the parties had specifically agreed to. it seems very bad policy to me to allow a party to have another party enter into a stipulation and then immediately turn around and change the, change the playing field.
Well, if that's a dirty trick, should we apply judicial estoppel and say she should have been barred from filing that termination action?
It's obviously within the discretion of the court, but I believe that it was anticipated that that was going to be coming. I think that the intention was to limit his interaction with his children so that later on there may be better grounds for abandonment, to be completely honest. To show that he hadn't been contacting them, he hadn't been writing them, none of those things were occurring. But certainly that makes for a better case for abandonment if later on the court can say, well, he didn't contact them during that time.
On appeal, did you in fact contest the statutory grounds for termination, or is consistent with the Court of Appeals opinion, did you in fact concede that termination had been proven by clear and convincing evidence?
Well, the grounds that he pled guilty to or was convicted of a crime against the child is true. That was true at the time that the decree was entered as well. So the ground was there, but the ground was there when we were talking about putting this stipulation together. I guess I wasn't involved in that, obviously, but when they were talking about putting that stipulation together, that was contemplated. It was definitely contemplated by the court because it was in the decree. That paragraph in there definitely states so, but the grounds existed at both times, and there's nothing that changes there. Obviously, if he's been convicted of a crime against the child, that doesn't change. The thing that does change is that one court says, I'm going to approve this. This is in the children's best interest. Another court, a couple months later, when no real change has happened,
So are we
says
really
that's
just
different.
arguing about what's in the best interest of the child?
That's the overarching consideration in every case like this.
All right, and so what's your position? Because what I'm troubled by a little bit is there's three different standards that we've all just been educated about under 598 and 600A and under 232. There's all these various standards that are out there. What's the standard that you think ought to be applied to our analysis of what's in the best interest of the child? Because we keep kind of going back and forth between 600A and whatever that standard is, but then I also heard your opposing counsel say that we can also look at 232 as well. So what standard are we supposed to apply on this best interest analysis?
Well, under Chapter 600A, the best interest analysis that's under Chapter 600A, that's what this was filed under, and I think that standard has to apply. I believe I'm out of time. Thank you, Your Honors.
Thank you. The case of in re the interest of QG and WG is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.